9 justices who cannot agree on almost anything involving the Second Amendment just agreed completely on one case, and the reasoning behind that agreement tells you more about where gun law is headed than the outcome itself does. On June 18, 2026, the Supreme Court ruled 9-0 in United States versus Himmani, and buried inside that unanimous vote is a legal test that federal prosecutors are going to be wrestling with for years. Here is the part almost nobody is explaining correctly. This case was not about whether the federal government can ban drug users from owning guns in general. It was about exactly how much evidence the government needs before it can prove a historical law from centuries ago actually justifies a modern one, and the court just set a bar that a whole category of existing prosecutions may not clear. Before I walk through how the court reached a unanimous result on a topic this contested, hit subscribe because this same historical analogy test is about to get applied to other federal gun restrictions, and I am tracking everyone as it moves through the courts. Tell me in the comments what surprises you more, that the vote was 9-0, or that several justices still wrote separately to say the underlying legal test itself is broken. To understand Hemani, you have to go back to 2022 and the Bruen decision, which set the modern rule for evaluating any gun law. Before Bruen, lower courts generally used a balancing test, weighing the government's interest in public safety against the burden a regulation placed on gun owners. Under Bruen, that balancing test disappeared entirely. The government cannot defend a firearm regulation just by arguing it serves a good purpose, or that the trade-off seems reasonable. It has to show the regulation is consistent with how the nation actually regulated firearms historically, going back to the founding era and the ratification of the 14th Amendment. That test sounds simple in theory and turns out to be brutally difficult in practice because prosecutors have to find genuine historical analogs, not just old laws that sound vaguely similar on the surface. 2 years later, in 2024, the court decided United States versus Himmani, upholding a federal law that disarms people subject to domestic violence restraining orders, and in doing so, it clarified that the government does not need to find a historical twin, an identical old law, but it does need what the court called a historical analog, a genuinely similar regulation with a similar justification. Himmani made the test slightly more workable for the government. Hemani shows exactly where that more workable test still has real teeth, because even under the more forgiving Himmani standard, the government's comparison in this case still failed. Here is where Himmani's specific facts matter, and the procedural history behind this case is worth understanding too, because it shows how long this exact legal question had been simmering before the Supreme Court finally settled it. Ali Daniel Himmani, a dual citizen of the United States and Pakistan, was under FBI investigation for reasons entirely unrelated to firearms. When agents searched his home, they found a Glock 9mm handgun, 60 grams of marijuana, and roughly 4.5 grams of cocaine. He admitted to regular marijuana use. The federal statute at issue, Section 922G3, bans firearm possession by anyone who is an unlawful user of a controlled substance, and prosecutors charged Himmani under that language in February of 2023. His defense argued that nothing in early American legal history supports disarming someone simply for being a regular user of a substance, absent any showing that he was impaired or dangerous when he actually had the gun. A magistrate judge agreed and recommended dismissal. While the district court weighed that recommendation, the Fifth Circuit Court of Appeals, in a separate but related case, had already found the same statute unconstitutional as applied to another regular marijuana user, reasoning that it could only be enforced against someone shown to be presently impaired. The government initially agreed Himmani's case should be dismissed under that precedent, while explicitly reserving the right to appeal, arguing the underlying Fifth Circuit reasoning was wrong. That reservation is exactly what eventually put the question in front of the Supreme Court. The government's move here was to reach for the closest historical comparison it could find, laws against habitual drunkards. On the surface, that looks reasonable, since historical societies did restrict rights for chronic, out-of-control drinkers, and courts have accepted similar analogies in other Second Amendment cases. But the court dug into what those old laws actually did in practice, not just what they were called, and found a real mismatch underneath the surface similarity. Habitual drunkard laws from the founding era and the decades that followed targeted people incapacitated by intoxication, people unable to function normally because of it, not anyone who simply drank regularly while otherwise going about ordinary life, holding a job and causing no disturbance. Early America, by every historical account, drank heavily as a matter of routine, And yet, even against that backdrop, the laws still reached only the incapacitated, not the merely habitual. Section 922G3, as applied to Himmani, reached him purely for being a regular user in the government's own framing, with zero evidence he was impaired or dangerous at the moment agents found the firearm in his home. That is a wholly different target than what the historical record actually supports, and the court said so plainly, ruling the government's analogy failed to carry the burden Bruen and Rahimi both require it to carry. There is a sentence buried in the opinion that deserves to be said out loud, because it is doing more legal work than almost anything else in the ruling. The court wrote that courts have a duty to say when regulation crosses the line into unconstitutional infringement, no less in the Second Amendment context than in any other. Think about what that sentence is instructing lower courts to do going forward. It is telling judges not to give firearms prosecutions a pass simply because gun regulation is politically sensitive or because striking down a federal statute feels like a bigger institutional lift than striking down a state one. If the government's historical justification does not actually match the modern law it is defending, judges are expected to say so plainly, the same way they would in any other constitutional context: free speech, search and seizure, due process, anywhere the government's evidence falls short of its burden. That instruction is arguably more consequential long-term than the narrow outcome for Himmani himself, because it applies to every future prosecution under this statute, and it hands defense attorneys around the country a template for challenging weak historical analogies wherever the government relies on them. That template is already being put to use. Because Himmani is an as-applied ruling rather than a facial one, its real impact depends entirely on how consistently lower courts apply its reasoning to defendants whose facts resemble Himmani's own. Public defenders and private firearms attorneys in multiple circuits are expected to cite this ruling almost immediately in pending Section 922G3 prosecutions, arguing that a client who used a substance regularly but was never shown to be impaired at the relevant moment deserves the exact same outcome Himmani received. Prosecutors, in turn, are expected to respond by building stronger records earlier in a case, documenting field sobriety observations, prior public intoxication incidents, or any pattern connecting drug use to actual dangerous conduct, precisely the kind of evidence the court found missing here. Watch for a wave of district court rulings over the next year that either extend Himmani's reasoning to nearly identical fact patterns or draw sharp lines distinguishing cases where real impairment evidence exists. That is where the actual weight of this decision will get decided, case by case, far more than in the opinion itself. Now, the 9-0 vote deserves real attention because unanimous outcomes on contested Second Amendment questions are rare enough to signal something. Justice Ketanji Brown Jackson, joined by Justice Sonia Sotomayor, wrote separately to say she joined the majority in full because it correctly applied Bruen and the 2024 Rahimi decision, but that she personally still believes the entire historical tradition framework is flawed and unworkable, forcing judges to sort through centuries-old evidence to answer contested historical questions. That is remarkable to see inside a unanimous ruling, a justice stating she thinks the whole methodology is broken, while agreeing completely that the government lost under that same methodology. It tells you the government's argument here was weak enough that justices who fundamentally disagree about how gun cases should be analyzed still landed in the same place. Here is what this actually means going forward, and this matters if you are watching federal firearms law generally, not just this one case. The ruling struck the statute down only as applied to Himmani's specific facts, a regular user with no showing of impairment or dangerousness at the time of possession. It did not strike the statute down on its face for every possible defendant, and Section 922G3 remains a valid federal law that prosecutors can still use. Himmani tells them exactly what kind of evidence will not survive a challenge anymore, mere regular use standing alone, without more. Watch for the Justice Department to lean harder on evidence of actual impairment or use at the time of possession when building future cases under this statute, essentially raising their own internal bar before charging someone, precisely to avoid handing defense attorneys an easy Himmani argument. There is also a wider legal landscape worth watching here because Himmani did not arrive in isolation. Other federal prohibited person categories are working through similar historical analogy challenges right now. Multiple petitions have raised Second Amendment challenges to the federal ban on gun possession by people with nonviolent felony convictions, and the Supreme Court denied review in a large batch of those cases earlier this year, leaving lower court rulings in place for now rather than resolving the historical analogy question at the felony level. Age-based restrictions on handgun sales to people under 21 have also been challenged on similar historical grounds, and the court declined further review there too, allowing existing restrictions to stand in at least one federal circuit while a split with another circuit remains unresolved. What Himmani shows is that the court is willing to apply real scrutiny when the government's historical evidence is genuinely thin, as it was here, while being far more cautious about disturbing settled restrictions where the historical case or the political stakes look different. That inconsistency, or perhaps discipline depending on your view, is exactly what makes predicting the next major ruling in this space so difficult. Step back and look at the real shape of this ruling. 9 justices spanning the court's entire ideological range agreed the government's historical evidence did not do the job required of it. This is not a case about whether drug use and gun ownership should mix as a matter of policy. It is a case about evidentiary rigor, about whether prosecutors can wave at a vaguely similar old law and call it a historical tradition, or whether they actually have to prove the match. The court just told every lower court in the country that vague waving is not enough. Not here, and not anywhere else the same test gets applied. If this finally explained what actually happened in Himmani instead of the oversimplified headlines calling it a blanket win for drug users and gun rights, hit that like button so the accurate version reaches more people. Subscribe, because this exact historical analogy scrutiny is about to get tested against several other federal firearm statutes, and I will break each one down the moment it drops. Comment below and tell me which prohibited person category you think gets challenged next using this same reasoning.